Today, what I want to talk about is the nature or the structure of a subject to transaction. There are a number of ways that you can structure a subject to transaction. The traditional method is to take title by warranty deed via a purchase contract. And then when you take title, obviously you're taking it subject to the existing loans on the property. When you take title and use this method, how you structure it is important. In my opinion, a subject to transaction should be structured with providing the seller with some form of security for you as the buyer's payment of the existing loans. So what I mean by that is you're going to deliver to the seller a promissory note that basically states, I am going to perform by paying the existing loan. So it's a performance note or a performance promissory note. I'm going to perform and I am going to pay the existing loans. And if I don't pay the existing loans, then you have a right to foreclose. And the way you would have the right to foreclose is I will give you, if you're in a deed of trust state, I will give you a deed of trust. So here in Arizona, we use deeds of trust to secure obligations. So I'm going to give you a deed of trust. And if you don't pay, if I, the buyer, don't pay, then you, seller, can foreclose under the laws of Arizona utilizing that deed of trust. Or outside of Arizona, it would be in states that use mortgages and not deeds of trust, it would be a mortgage. So if I fail to pay those existing loans as agreed, then you have the ability to come in and foreclose using the mortgage. So according to the laws of the state, I go through the foreclosure process and I foreclose on that mortgage. This is what we call and has been traditionally called a wrap transaction, where you basically take a promissory note and a security instrument, such as a deed of trust or a mortgage, and you wrap the existing financing. So it's wraparound. You basically wrap it with a note and deed of trust given to the seller that secures the buyer's performance of paying the existing loans. The reason why I like a wrap transaction as opposed to basically entering into a purchase contract, taking the property with a warranty deed and just taking it and saying, well, I'll pay the loans or agreeing in the purchase contract to pay the loans, but not giving the seller any form of loan instrument or security instrument is a couple of reasons. One, I like it better because wraps have been around for forever. And in the legal realm, most real estate attorneys are going to know what a wrap agreement is or a wrap transaction is. If the transaction is ever challenged in court, you could go into court and say, Judge, this is a wrap. This was a wrap transaction. And most judges say, oh, okay, I understand what a wrap is, versus this is a subject to, I receive a warranty deed, but then I didn't give the seller any security. A judge may look at that and say, well, wait a minute, how's the seller protected in this transaction? And call into question the nature of the transaction. You still might prevail as the buyer, but having it as a wrap transaction gives it an air of legitimacy because wraps have been around for so long, and most real estate attorneys are familiar with them, have prepared them, and are used to working with wrap transactions. The terms subject to, sub to, that's kind of a newer thing, and so some of the older attorneys, even judges, may not be familiar with those terms and those transactions, and would require extra education. Second is, by giving the seller a promissory note, you're giving the seller basically an asset that it can use potentially to show to a future lender that shows, hey, look, I'm receiving these monthly payments under this note. And that should offset some of the debt to income issues that they might have on obtaining additional financing. It also provides a certain level of protection in the event of, what happens if the seller, passes away or files for bankruptcy or things like that. You then have a document that exists that basically is an asset, even though it basically mirrors the existing loan. It's still something that can be assigned. You can assign the promissory note and the obligations under the promissory note to, say, a bankruptcy trustee or to heirs of an estate, versus if all you do is have an obligation in a purchase contract and then you take title by warranty deed without giving the seller any, form of traditional security. You don't have that ability in those instances. So in my view, when you do a subject to transaction and you're going to perform that transaction by a purchase contract followed by a warranty deed whereby the buyer takes title, you should wrap that transaction or wrap the existing loans also using a note and some form of security instrument like a deed of trust or mortgage.